Declaration of compulsory education areas and compulsory school ages. 20. The minister may by order declare a. Any area within a radius of 3 miles from any school specified in such order to be a compulsory education area, and b. The compulsory school age in relation to such compulsory education area. Duty of parent to secure education of their children. 21. It shall be the duty of the parent of every child of compulsory school age residing in a compulsory education area to cause him to receive full-time education suitable to his age and ability and satisfactory to the educational board for the area, either by regular attendance at school or otherwise. 1F. Any child of compulsory school age in a compulsory education area who is a registered student at a school fails to attend regularly thereat, the parent of the child shall be guilty of an offense against this section. 3. In any proceedings for an offense against this section, the child shall not be deemed to have failed to attend regularly at school by reason of his absence therefrom. A. At any time when he was prevented from attending by reason of sickness or any unavoidable cause. B. With leave granted by any person authorized in that behalf by the owners or the board of management of the school. C. If the parent proves that the school at which the child is registered is not within walking distance of the child's home. 4. In this section, walking distance means, in relation to any child who has not attained the age of 8 years, 2 miles, and in relation to any other child, 3 miles, measured in each case by the nearest available route. 5. Any person who is guilty of an offense against this section shall be liable on summary conviction before a resident magistrate, in the case of a first conviction, to a fine not exceeding $1, in the case of a second conviction, to a fine not exceeding $4, and in the case of a third or subsequent conviction, to a fine not exceeding $10 or to imprisonment for a term not exceeding 14 days or to both such fine and such imprisonment. 6. Where the court before which a prosecution is brought for an offense against this section or section 22 is satisfied. B. That the child in respect of whom the offense is alleged to have been committed has failed to attend regularly at the school at which he is a registered student, or B. That a person who is alleged to have failed to comply with the requirements of an attendance order is guilty of an offense against Section 22. The court may, whether or not the parent is convicted, direct that the child in respect of whom the offense is alleged to have been committed be brought before a children's court by the person or authority by whom or on whose behalf the proceedings were instituted, and the children's court may, if it is satisfied that it is necessary so to do for the purpose of
securing the regular attendance of the child at a school, make any order which such a court has power to make under Section 82 of the Child Care and Protection Act in the case of children who are brought before it under Part 3 of that Act. 7. For the purposes of the Child Care and Protection Act, any child with respect to whom a direction has been given under this section that he be brought before a children's court shall be deemed to be a child about to be brought, or brought, before such a court under Part in of that Act, and any order made by a children's court under this section shall be deemed to be an order made under Section 82 of that Act, and all the provisions of that Act shall have effect accordingly, but subject to the modification that in relation to any such child subsection 1 of Section 12 of that Act shall have effect as if the words or any person to whom a direction has been given under subsection 6 of Section 21 of the Education Act were inserted therein next after the word constable. 8. In this section and sections 22, 23 and 24, any reference to a resident magistrate, insofar as it relates a. to a Resident Magistrates Court for the Parish of Kingston or for the Parish of St. Andrew, shall, as respects any time on or after the 13th day of November, 1978, be construed as a reference to the Family Court Corporate Area Region, and b. to the Resident Magistrates Court for a parish within the geographical jurisdiction of a family court established pursuant to Part I-1 of the Judicature, Family Court, Act, shall, as respects any time on or after the date on which such court is established, be construed as a reference to that Family Court. 22. L. If it appears to the Educational Board for any compulsory education area that the parent of any child of compulsory school age residing in such area is failing to perform the duty imposed on such parent by Section 21, the Educational Board shall serve upon the parent a notice requiring him, within such time as may be specified in the notice, not being less than 14 days from the service thereof, to satisfy the Educational Board, that the child is receiving full-time education suitable to his age and ability and satisfactory to the Educational Board, either by regular attendance at school or otherwise. 2. If a parent upon whom a notice is served under this section fails to satisfy the Educational Board in accordance with the requirements of the notice that the child to whom the notice relates is receiving full-time education suitable to his age and ability and satisfactory to the Educational Board, then, if in the opinion of the Educational Board it is expedient that he should attend school, the Board shall serve upon the parent order, hereinafter referred to as a school attendance order, requiring the parent to cause the child to become a registered student at a school named in the order, provided that the Educational Board may at any time, at the request of the parent, substitute another school for the school named in the order. 3. If any person upon whom a school attendance order is served fails to comply with the requirements of the order, he shall be guilty of an offense against this section unless he proves that he is causing the child to whom the order relates to receive, otherwise than at a school, full-time education suitable to his age and ability and satisfactory to the Educational Board. 4. If in any proceedings against any person for a failure to comply with a school attendance order that person is acquitted, the court may direct that the school attendance order shall cease to be in force, but without prejudice to the duty of the Educational Board to take further action under this section, if at any time the Educational Board is of the opinion that having regard to any change of circumstances it is expedient so to do. 5. Except as provided in subsection 4, a school attendance order made with respect to any child shall, subject to any amendment thereof, which may be made by the Educational Board, continue in force so long as such child is of compulsory school age, unless such order is revoked by the Educational Board. 6. Any person who is guilty of an offense against this section shall be liable on summary conviction before a resident magistrate, in the case of a first conviction, to a fine not exceeding $1, in the case of a second conviction, to a fine not exceeding $4, and in the case of a third or subsequent conviction to a fine not exceeding $10 or to imprisonment for a term not exceeding 14 days or to both such fine and such imprisonment. Authorization and powers of attendance officers. 23. 1. It shall be lawful for any person authorized in that behalf by an Educational Board, which person is hereinafter referred to as an attendance officer, at any time between the hours of 7 o'clock in the morning and 6 o'clock in the evening on any day to enter any premises and there, a. make such inquiries as may be necessary to determine whether the provisions of Section 21 or Section 22 are being complied with in relation to any child whom he has reasonable cause to believe to be residing or employed on such premises, or b. serve on any person a notice under Section 22 or Section 24. 2. 2. Every attendance officer shall be furnished with a certificate of authorization by the Educational Board for the area concerned, and upon entering any premises as aforesaid, he shall, if required so to do, produce to the occupier his certificate of authorization. 3. Any person who, a. assaults or obstructs any attendance officer while such attendance officer is acting pursuant to any power vested in him by this act, or, b. having been requested by any attendance officer to give any information of which he may be possessed as to the name, age, residence, parent, employment, or attendance at school of any child, fails without reasonable cause to give such information to the attendance officer, or, c. knowingly gives to any attendance officer any false or misleading information as to the name, age, residence, parent, employment, or attendance at school of any child, shall be guilty of an offense against this section, notwithstanding that any child in relation to whom such offense is alleged to have been committed is not of compulsory school age, and shall be liable on summary conviction before a resident magistrate to a fine not exceeding $40. Children requiring special educational treatment 24. 1. The Minister may direct the Educational Board for any compulsory education area to ascertain for his information which children of compulsory school age residing in such area require special educational treatment, and after considering the report of the Educational Board the Minister may take such steps as he thinks fit to provide for the education of any such children requiring special educational treatment. 2. For the purpose of carrying out the directions of the Minister under this section an Educational Board may cause to be served upon the parent of any child of compulsory school age residing in a compulsory education area in respect of which such directions were given, a notice requiring the parent to submit the child, at a time and place specified in the notice, for examination by a medical officers for advice as to whether the child is suffering from any disability of mind or body and as to the nature and extent of any such disability. 3. If any parent upon whom a notice is served under this section fails without reasonable cause to comply with the requirements of such notice he shall be guilty of an offense against this section, and shall be liable on summary conviction before a resident magistrate to a fine not exceeding $4. And where such offense is continued after conviction the parent shall be guilty of a continuing offense and in respect of each day during which that offense continues shall be liable to a fine not exceeding $2.